1919, in this summer, the British Empire passed a law to cripple the rising voices of revolution and freedom. The law required no evidence, no trial, and no court, no right to counsel. It needed only one suspicion. The Rowlatt Act of 1919, the Anarchical and Revolutionary Crimes Act of 1919. And it did not stop a single revolution. It started one. More than a century later, in the summer of 2026, the West Bengal Legislative Assembly passed a law that also requires no evidence, no trial, and no court or legal counsel to review the case. It too needs only one suspicion. And today, we will discuss the nuances of the law and how there is possibility of probable misuse against identified enemies. Tonight, we are going to read this law sentence by sentence and ask the only one question that has ever mattered when a government asks its citizens to trust it with unchecked power. Who exactly gets to decide who is dangerous and threat to the society? Let us begin with the names, because names are the first place power likes to hide. The legislation passed by the Assembly is not one bill, but two. The first is called the West Bengal Public Safety and Control of Anti-Social Activities Bill 2026. The second is the West Bengal Maintenance of Public Order Amendment Bill 2026. Together, the public now calls it simply the Goonda Bill or the Anti-Goonda Act. A district magistrate, a commissioner of police, or any other officer not below the rank of Deputy Inspector General can detain a person for up to 12 months without a trial. They can order a person to be expelled from the entire district for a full 1 year. For a full 1 year, I repeat, on the suspicion alone that the person is a Goonda or the person might create a riot or disturbance in the certain area or a certain locality. Here is the problem that we get into. Who is a Goonda? What are the parameters to define a Goonda? Not only the habitual offender, not only the charge-sheeted gangster or the history sheeter, but, and I want you to sit with this phrase, anyone for generally reputed to be desperate and dangerous to the community. End quote. So it will be defined by the authorities. Now let's see. Reputation, no evidence. Reputation, a word of gossip repeated by the wrong official can now cost a citizen their freedom for a year. The assembly vote itself tells its own story. 176 members voted in favor of the bill. 40 members voted against the bill and 20 abstained. That means they stayed silent, perhaps for the reasons we only can speculate. And there is a second law riding alongside the first, one that lets the state hold not just the person who throws a stone accountable, but the organizer, the financer, the instigator, even the logistical supporter of any protest that turns violent. Their property can be attached, auctioned, recovered as areas of land revenue. Now, if you are going to do a protest, will the decorator provide his equipments, or will they rent that hall? Because they will be held accountable as well, just because they have rented the hall, and the protest that you have staged, the government does not like that. Now ask yourself, how easily could financer of unrest be redrawn by an unfriendly official to mean organizer of a peaceful protest that a mob later hijacked? Now let us return to 1919, because history, when it repeats itself, rarely announces its arrival. The Rowlatt Act permitted detention without trial. It permitted minimal judicial review. It was used overwhelmingly against nationalist leaders, against Gandhi's Congress, against the freedom movement itself. Similar to this was another law very often used by the British rulers was the Sedition Act. Section 124A of the Indian Penal Code 1860. The act labeled offence as, and I quote, to bring or attempt to bring into hatred or contempt or excite or attempt to excite disaffection towards the government established by law. Now, the term disaffection was vague, and the Britishers used this to define any form of protest or rebellion as disaffection, like disloyalty or feelings of enmity or hatred or contempt against the British Raj. The British administration used the law primarily against newspaper editors, journalists, political leaders, writers, pamphleteers, public speakers, publishers, freedom fighters, revolutionaries, and who not. All this provoked such fury, such grief, such righteous rebellion that it led rising attacks by revolutionaries and protests or movements by the Congress and similar political organizations. A century of constitutional evolution stands between that law and this one. And yet, listen closely to what critics of the new bill are saying. People have protested and reminding that there are sufficient provisions in the Indian Penal Code, now the Bharatiya Nyaya Sanhita, to deal with antisocial activities. This proposed law is more draconian than even the National Security Act. More draconian than the National Security Act. Let that classification settle in your mind. Also, opposition is arguing that the bill's language leaves the scope for arbitrary action and could be invoked selectively against political dissent. This is the pattern that connects 1919 to 2026. Our government defines who is danger or which group is anti-national. They get to decide who are loyal and who aren't. They decide who fit the definition, and a citizen is left with almost no locus standi, no forum in which to argue back before the damage to their liberty is already done. To be precise and to be fair, because precision is the only honest foundation for outrage. This is not a literal resurrection of a colonial statute. It is sometimes perhaps more troubling. An independent democratic legislature elected by its own people, choosing to walk back toward the very legal logic its founding fathers fought a century to escape. Our leaders have fought against the imperial British Raj to create a democratic society, a society where everybody would have the right to equality and the right to liberty. Liberty, equality, fraternity is the basis of our constitution. Thomas Jefferson, one of the pioneers of democracy, a founding father and the third president of United States from 1801 to 1809, warned that even an elected legislature, if left unchecked, would naturally try to consolidate total power. He said, quote, an elective despotism was not the government we fought for, but one which should not only be founded on free principles, but in which the powers of government should be so divided and balanced among several bodies of magistracy as that no one could transcend their legal limits without being effectually checked by the others. Every law that grants a government the power to detain without trial, sooner or later being turned against the very people our democracy exists to protect. This is not speculation. This is India's own documented record. Consider the National Security Act of 1980. Journalists, activists, ordinary citizens who spoke too loudly against those in power or who protested, detained under its provisions, only for courts a month later to quash the very orders that had already stolen their freedom. Justice delayed in these cases were not merely justice denied, it was liberty already consumed, liberty destroyed. Consider the Jammu and Kashmir's Public Safety Act. Amnesty International and India's own domestic human rights organizations have documented repeatedly It's used against students, against reporters, against political leaders whose only crime was inconvenience to those who governed them. Amnesty documented how authorities used the PSA to keep individuals out of circulation without a trial. If a regular criminal court granted bail to the individual due to lack of evidence, authorities immediately issued a new PSA order and kept them detained. This loop trapped individuals in prison for years without ever being formally charged. The report that noted that while the law was originally enacted in 1978, ostensibly to target timber smugglers, it had widely been applied against political activists, human rights defenders, journalists, and peaceful protesters. 8,000 to 20,000 people were reported to be detained under the PSA. The NHRC's ability to directly investigate human rights violations by armed forces and security apparatus in Jammu and Kashmir has been historically heavily restricted under Section 19 of the Protection of Human Rights Act 1993. But the National Human Rights Commission has frequently intervened regarding individual cases of custodial deaths, arbitrary killings, and protection of minorities in the region. Consider the Maintenance of Internal Security Act 1971 MISA, the law that became the very emblem of emergency of 1975 when a government detained its political opponents en masse without trial, without mercy, in the name of just and order. And consider the state-level Gunda and Gangster Acts already operating in Maharashtra, Gujarat, and Uttar Pradesh, laws the West Bengal government itself cites as its inspiration, laws with their own documented history of being turned against activists and political rivals, not merely against the criminals they claim to target. Here then is the mechanism laid bare. Vague definitions let officials decide unilaterally who is dangerous. Detention arrives before any court has found anyone guilty of anything. No lawyer stands beside the accused when the advisory board first reviews their fate. Appeals, when they finally arrive, take months. And by then a life has already been interrupted, a career already destroyed, a family already fractured. The whole life of that person is shattered. This is the pattern history begs us to recognize. First, such a law targets criminals and public applauds. They are overwhelmed by the actions of the government. Then it targets the protesters and the public hesitates. Then quietly it targets anyone inconvenient to power. And by then the public has lost the vocabulary and the legal machinery to object. Let me be direct, because a moment like this does not call for euphemism. When any government of any party in any state under any banner reaches for the language of public safety to justify detention without trial, and legal representation and executive discretion over who counts as dangerous, it is not protecting its citizens. It's protecting itself from scrutiny, from dissent, from accountability. This is not governance. That is the architecture of impunity dressed in the language of order. So let us close where every conversation about liberty must close, with the Constitution itself. Article 21 guarantees the right to life and personal liberty. This law places the guarantee at risk, permitting detention for up to 12 months without conviction and without trial. Article 19, Clause D and E guarantee freedom of movement and residence across the territory of India. This new law places that guarantee at risk, permitting exclusions from an entire district for a year on the suspicion alone before anything is proven. Article 19, Clauses A and B guarantee freedom of speech and the right to peaceful assembly. This draconian law, places that guarantee at risk. Its broad definition of antisocial activity capable in careless or malicious hands of sweeping in protesters and organizers alongside genuine criminals. The Article 22 guarantees protection against arbitrary arrest and detention. This law places that guarantee at risk as well, denying a detained citizen the right to legal counsel before the very board reviewing their fate. Among the 6 fundamental rights of the Indian citizen enshrined in the Constitution of India found in Part 3, Article 12 to 35, is the right to constitutional remedies, Article 32. This right is curtailed only on the basis of suspicion. Another two rights are the rights of freedom of religion, Article 25 to 28, and the cultural and educational rights, Article 29 to 30. Ministers or legislators in power says that a certain section has voted for them, and he and his government will work only for that section who has voted for them. Whereas in a healthy democracy and such a diverse nation as India, it is expected that those who have not voted for the candidate or the political party, it is their responsibility. It is the responsibility of the revered member of the Parliament or State Assembly to work for them and listen to their grievances and help them out, so that the next time they vote in favor of them, you try to bring them towards your side by working for them. But here we completely hear a paradox from the democratically elected government that is in power. They are saying that they will not work, they will deprive them of their basic rights. Now, the new law also curtails the right against exploitation. Articles 23 to 24. An individual in power may be in a constitutional position or a high government official can define a personal rival as Gunda or a potential threat to the society and detain and harass him or her to extract revenge or any equity that they want. These are the basic and the foundational promises. These are the basic and foundational promises the Constitution makes to every Indian citizen. And one piece of legislation passed in a single assembly session that touches every single one of them. Hannah Arendt, who deeply analyzed the rise of totalitarian regimes in the mid-20th century, noted that the preparation for totalitarian rule inside democratic society starts when people lose their sense of reality and critical thinking. The ideal subject of totalitarian rule is not the convinced Nazi or the convinced communist, but people for whom the distinction between fact and fiction, that is the reality of experience, and the distinction between true and false, that is the standards of thought, is no longer exist. Edward Murrow, speaking out during the height of McCarthy era political overarch in the United States, reminded the public where the blame ultimately lies. And he said, quote, "We must not confuse dissent with disloyalty. We must remember always that acquisition is not proof and the conviction depends upon evidence and due process of law. We will not walk in fear one of another. We will not be driven by fear into an age of unreason. If we dig deep in our history and our doctrine and remember that we are not descendant from fearful men, not from men who feared to write, to speak, to associate and to defend the causes that were for the moment unpopular, the actions of the Bureau cannot be blamed on the system. The fault, dear Brutus, is not in our stars but in ourselves." So here Hannah Arendt says that when there is a rise in the totalitarian rule, it is not convinced Nazi or a convinced communist is in totalitarian power, but it is the people. The people forget the difference between fact and fiction, true and false. They cannot distinguish amongst anything what is going on, whether it's right or whether it's wrong, and they just agree to the fundamentalist power. Edward Murrow says that there is a difference between dissent and disloyalty. You can disagree with the government, you can criticize the government, you can question the actions of the government. That does not mean that you are disloyal to your country. Loyalty towards the country has nothing to do with disagreement or dissent from the government. The government is a body of elected representatives from a political party which gained the majority of vote share of the country. But it does not mean that it is a dictatorial, totalitarian and fundamentalist power. The citizens of the nation who have voted for them and who have not, it doesn't matter, have the power to question the government. The government insists this law will be used only against criminals. That restraint, not the statute's text, will be the true safeguard. But History has never once recorded a government that promised restraint and then bound itself to it, once the law had already granted it the power to do otherwise. We are not asking whether organized crime is real. It is, we all know about it. We are not asking whether public disorder deserves a firm response. It does. We are asking something narrower and something far more important: whether a democracy can address disorder without dismantling the very due process that separates it from the empire it once overthrew. Gandhi's philosophy of satyagraha was entirely built on the premise that citizens have a moral duty to rebel against a government that acts like a dictator. And he said, and I quote, "An unjust law is itself a species of violence. Arrest for its breach is more so." Now, the law of nonviolence says that violence should be resisted not by counter-violence but by non-violence. This I do by breaking the law and by peacefully submitting to arrest and imprisonment. He frequently warned that a government's authority comes from the people, and if a state uses its laws to commit atrocities against its own people, those laws lose all legitimacy. Netaji Subhash Chandra Bose, in his address to the INA in 1943, he warned that an autocratic power will never give up its control willingly, and the citizens must be prepared to risk everything when a government turns tyrannical. It is our duty to pay for our liberty with our own blood, the freedom that we shall win through our sacrifice and exertions. We shall be able to preserve with our own strength. In 1919, a people who had no vote, no parliament, and no constitution still found the courage to say no to a law exactly like this one. Today we have all three. The only question left is whether we will use them. This has been an independent civic analysis of the West Bengal Public Safety and Control of Anti-Social Activities Bill 2026 and its accompanying amendment. Read the bill, read the Constitution yourself, and decide for yourself. No one is asking to create disorder in the society or create ruckus in the society or in the country, but all the citizens of India has the right to question the government, and the Constitution of India guarantees and provides those rights to its own very citizens. So let us follow the philosophy of Gandhi, the philosophy of non-violence, and protest against any wrongdoing that we see in the society.